From The Australian, here's what's on the front. I'm Chris Dawson. It's Tuesday, June 10, 2025. Newly minted opposition energy and emissions reduction spokesman Dan Tehan says he'll take his time on the fate of the coalition's contentious net zero target. He says there'll be a conversation about nuclear too, but any future models won't replicate the one proposed by ousted Liberal leader Peter Dutton. Criminal cases involving Aboriginal people could be heard in closed court or by female judicial officers. Those are the new guidelines given to judges in a revised New South Wales bench book. That exclusive story is live right now at theaustralian.com.au. Chris Dawson has launched a last-ditch bid to have his conviction for the 1982 murder of his wife quashed. The High Court of Australia will this week consider an application made by the former rugby league star for special leave to appeal a finding that upheld the conviction. That's today's episode.
Christopher Michael Dawson on the charge that on or about 8 January 1982 at Bayview or elsewhere in the state of New South Wales, you did murder Lynette Dawson. I find you guilty. You may sit down.
This was a moment more than 40 years in the making. On a bright winter's day in 2022, New South Wales Supreme Court Justice Ian Harrison found Chris Dawson guilty of the murder of his first wife, Lynette Sims, who vanished from their home at Bayview in the early 1980s. She was 33 years old, a doting mum to 2 little girls, and a dedicated employee at a childcare centre on Sydney's northern beaches. Her fate was unknown for decades until the Australian's podcast The Teacher's Pet, created by National Chief Correspondent Hedley Thomas, exposed Lynette's husband, Chris Dawson, as a murderer. He's always maintained he played no role in Lynette's disappearance and claims she left the family, her daughters, her husband and the home she loved, of her own accord. The story captured national and international attention, and in late 2018, within months of the podcast's release, police arrested and charged Chris Dawson with Lynette's murder.
The key thing to come out of this, Davina, is that the police are now confident of a prosecution. Remember, a coroner twice has recommended charges in this case, and the DPP in the 80s said no. But now they believe they have enough evidence.
More than 3 years after his arrest, Justice Ian Harrison would find Chris Dawson murdered Lynette to replace her with a teenage babysitter who'd become his second wife. Dawson was sentenced by Justice Harrison to 24 years in prison, with a non-parole period of 18 years.
I recognise that the unavoidable prospect is that Mr. Dawson will probably die in jail. Mr. Dawson, would you please stand?
The New South Wales government introduced no body, no parole legislation, known as Lynn's Law, in the months following Chris Dawson's conviction. That means he won't be eligible for parole unless he reveals the location of Lynette's remains to the authorities. In 2024, Chris Dawson launched a bid to quash his murder conviction in the New South Wales Court of Criminal Appeals, arguing he suffered a forensic disadvantage in proving his innocence due to the long delay in bringing the case to trial. He also argued there'd been a miscarriage of justice due to Justice Harrison's reliance upon lies allegedly told by Chris Dawson following Lynn's murder as evidence of a consciousness of guilt, and that the verdict was unreasonable because the Crown's case was wholly circumstantial and a hypothesis consistent with Dawson's innocence wasn't excluded beyond a reasonable doubt. Chris Dawson's barrister in the appeal, Belinda Rigg SC, told the court transactions were made on Lynette's bank card in the weeks following her disappearance, and that she'd called the kiosk at the Northbridge Baths, where he worked part-time as a lifeguard, to let him know she needed some time to herself, but the proof had been lost to time. The 3-judge panel of Justices Julie Ward, Christine Adamson and Anthony Payne unanimously dismissed the appeal, writing that Justice Harrison's reasoning was sound, that the Crown's circumstantial case was compelling, and that Chris Dawson failed to establish that the 40-year delay in bringing charges had caused him a forensic disadvantage. A voice actor is reading part of the Justice's reasons.
First, given the applicant's different versions of events, it was unclear whether the unavailability of certain bank card statements was relevant, and, in any case, it was his own failure to retain those statements, not any delay, that caused them to be unavailable. Secondly, the lack of records showing the applicant was working at the Northbridge Baths on 9 January 1982 caused no disadvantage, since the Crown conceded the applicant was working there on that day. Thirdly, records of phone calls made to the Northbridge Baths on 9 February 1982 were unavailable because of limited technology at the time, not because of delay, and records of phone calls to the applicant's house would not have assisted the applicant.
Now, Chris Dawson is taking the fight to the nation's highest court in a last-ditch effort to have his murder conviction quashed. For 2 weeks every month, the High Court of Australia sits in Canberra to consider a whole range of civil and criminal matters. Chris Dawson has applied for special leave to appeal his murder conviction. That means he's asking the High Court to grant him an appeal hearing. If that application is granted on Thursday, he'll ask the court to quash the 2022 murder conviction made by Justice Harrison and grant him a new trial.
Well, I think this is Chris Dawson's final roll of the dice insofar as his attempt to beat the murder conviction of 2022 goes.
Hedley Thomas is the Australian's national chief correspondent and the creator of the Teacher's Pet podcast.
Now he's seeking leave from the High Court to run similar arguments that his conviction should be quashed, and much of his argument turns on his claim that he had a significant forensic disadvantage because of the age of the case and the failure, in his view, of the police at certain stages.
A voice actor is reading part of the grounds of the former schoolteacher's High Court application.
The Court of Criminal Appeal erred by failing to find that the applicant's trial miscarried because the trial judge failed to find that the applicant suffered a significant forensic disadvantage. The Court of Criminal Appeal erred by failing to take the applicant's significant forensic disadvantage into account when considering whether the verdict was unreasonable and unable to be supported by the evidence.
Chris Dawson says significant witnesses, namely Sue Butlin, who purportedly saw Lynn Dawson getting into a car at a fruit shop on the New South Wales Central Coast, had died by the time the case was tried by Justice Harrison alone in 2022, and that important documents from the abandoned initial homicide investigation had been lost.
We have in Sue Butlin the wife of a guy called Ray Butlin. Ray Butlin was a rugby league coach on the Central Coast, and he got to know and coached the Dawson twins, Chris and Paul, after they'd finished their professional careers with the Newtown Jets. The version that we have from either Chris Dawson or Ray Butlin is that Sue Butlin saw a woman she believed was Lynn Sims in a vehicle at a fruit barn on the Central Coast. Shortly after, the Crown says Chris Dawson murdered Lynn in the home at Bayview on the Northern Beaches. Now, we don't have any direct evidence from Sue Butlin about that. What we do know, because Ray Butlin disclosed this in the inquest where he was questioned about his wife's purported sighting of Lynn, and Ray Butlin said of his own wife, who had been dead for some years, that she did have a tendency to exaggerate things and she might have embellished the story. However, he felt sure that if she were on the stand, she would say, "Yeah, I saw Lynn." Now, the problem here is that the police investigation in the early 90s stopped as a result of Chris Dawson telling homicide detectives that his mate's wife saw Lynn. But there's no evidence of any attempt by those homicide detectives to try to corroborate Chris's claims that his mate's wife saw Lynn. So the police didn't go directly to Sue Butland, who was still alive in 1992, to take any kind of statement from her. So there's nothing in writing. There's just this hearsay account. And this is being held up as one of the pieces of evidence that was crucial to Chris Dawson's defence and should have been obtained. And I think that many people who have followed this case closely would think that, yes, the police should have got a statement, but that police failures in this case early on cut both ways. It is strongly arguable, in my view, that if police had done a much better job in the early stages after Lynn's disappearance, then Chris Dawson would have been prosecuted and convicted of murder very early on. So it doesn't necessarily follow that he has been denied justice. It may be that he's actually experienced freedom because of the police failures and the delays in doing things.
The application argues there's no onus on Chris Dawson to establish the delay certainly caused him a significant forensic disadvantage, only that there's a real possibility that it did.
It is unnecessary that each individual lost witness or document singly would have demonstrated innocence, but rather that collectively, the lost evidence would have likely strengthened the applicant's position at trial.
John Paul Cashin is a partner at law firm Thompson Gear, which advises The Australian.
It's an interesting one because in Australia, we don't have a statute of limitations. Here, if someone's committed murder or any serious offence really, we can bring a charge against them 10, 20, 30, 40, 50 years after the fact. And I think courts are reluctant to say that the mere fact that there's a delay means that someone can't be brought to justice. And what happened was in the late 1980s, there was a case called Longman where the charges had been brought about 20 years after the alleged offending. And in that case, the court warned the jury that there was a real risk that the evidence was unreliable. And that led to an acquittal. And there was a feeling after that case that it shifted the boundary too much in the favour of acquittals. And so they changed the law to bring it back a little more in favour of the policy of, well, just because there's a delay doesn't mean you can't face trial. And that's what this appeal is really all about. In this case, there's no doubt that Dawson has suffered some prejudice because of certain evidence going missing. And so he said, well, he was never able to truly test that. And the Court of Appeal ultimately has to draw a line and say, well, did you suffer a significant forensic disadvantage because of these things? And the Court of Appeal said, no, it was just speculative that these things would have helped him. There wasn't an actual prejudice. And he's upset about that. He says now, no, that puts the test too high. That shifts the burden too far in favour of conviction. And that's really the essence of this appeal before the High Court now. Where do we draw that line?
Chris Dawson also says the Court of Criminal Appeal got it wrong when it upheld Justice Harrison's reliance on lies allegedly told by him as evidence of consciousness of guilt because he had other reasons to lie.
One of the key parts of the first appeal was that Justice Harrison had incorrectly looked at the lies told by Chris Dawson. So one of the key ways a person gets convicted is when they lie to police, and those lies are evidence of what we call consciousness of guilt. And sometimes a lie will be strong consciousness of guilt, but sometimes people lie for other reasons. And indeed, in Dawson's case, there was a suggestion that he might have been lying about certain things, not because he'd killed Lynette, but because he was embarrassed or trying to hide the fact that he was having a relationship with his former student. And the Court of Appeal found that Justice Harrison didn't deal with those lies and that consciousness of guilt appropriately. So they did find that he'd made an error in relation to those questions, but they have a broad discretion to say, well, even if the trial judge made an error, we're not going to overturn his decision unless we find that a substantial miscarriage of justice occurred. And in this particular case, they found that there wasn't a substantial miscarriage of justice. So that will also form part of the High Court judgment. And it sort of rolls into that same question about, well, what is the total cumulative amount of prejudice suffered by the accused in this case? Is it enough to overturn his conviction?
Coming up, why this isn't Chris Dawson's first High Court rodeo. This isn't the first time Chris Dawson has made an application to the High Court. After his arrest, applications for a permanent stay of proceedings were dismissed by Justice Elizabeth Fullerton in the Supreme Court of New South Wales and later by the Court of Criminal Appeal. Here's Hedley Thomas.
Well before the murder trial in 2022, Chris Dawson was determined to try to avoid trial altogether, and he wanted to persuade the courts that he could not get a fair trial as a result of failures of police to find evidence that he says would have been in his favour, that would have shown in his claims that his wife Lynn had not been murdered, that in fact she'd probably started a new life. And secondly, he claimed that he couldn't get a fair trial because too many people had listened to or heard about the teacher's pet and had a fixed view of his guilt. Now, he failed in those attempts to get a permanent stay of proceedings, and his final bid was to the High Court, and that was denied shortly before the murder trial in 2022. When Chris Dawson was trying to avoid trial altogether, he relied on a leading criminal defence lawyer, Philip Bolton. And then for the criminal trial, Philip Bolton was not in that. In fact, that was run for Chris Dawson by a defence lawyer called Pauline David, and she had known Dawson many years earlier. In fact, when Chris Dawson was interviewed by homicide detectives in 1992 on the Gold Coast, a much younger Pauline David was Chris Dawson's solicitor during that interview. Then we go forward 30 years. Philip Bolton didn't get involved in the murder trial to our knowledge. However, Pauline David, at the end of the trial, was appointed to the District Court of New South Wales as a judge. So Philip Bolton has returned and he's running this appeal to the High Court, and in documents that have been filed, he has highlighted what he says were numerous errors by the New South Wales Court of Criminal Appeal in its findings, which said that Chris Dawson should not succeed with his bid for freedom.
Hedley Thomas is the Australian's national chief correspondent. You can listen to The Teacher's Pet and access the nation's best journalism anytime at theaustralian.com.au.